Welcome to SCOTUScast, a project of the Federalist Society for Law and Public Policy Studies. Our contributors join us from around the country to bring you expert commentary on U.S. Supreme Court cases as they are argued and decisions are issued. The Federalist Society takes no position on particular legal or public policy issues. All expressions of opinion are those of the speaker.
Welcome to the October 2021 term of SCOTUScast. I'm your host, Nick Garfinkel, on behalf of the Faculty Division of the Federalist Society. On March 3rd, 2022, the U.S. Supreme Court decided Cameron v. EMW Women's Surgical Center. Writing for the 8-1 majority, Justice Samuel Alito wrote that the U.S. Court of Appeals for the Sixth Circuit erred in denying the Kentucky Attorney General's motion to intervene on the Commonwealth's behalf in litigation concerning Kentucky House Bill 454 relating to the rights of the unborn. Justice Thomas filed a concurring opinion. Justice Kagan filed an opinion concurring in the judgment, in which Justice Breyer joined. Justice Sotomayor filed a dissenting opinion. Joining today to discuss this decision is Philip D. Williamson, partner at Taft, Stettinius, and Hollister, LLP.
Thanks, Nick. It is a pleasure to be on, and thank you to all of you for joining and letting me chat for a bit today. So we recently got the decision, as Nick said, in Cameron versus EMW. And, I'll start with the big headline for everyone who has to hop off in the first 5 minutes. A district court in Kentucky enjoined enforcement of an abortion regulation in a suit against the Kentucky governor's office. A divided Sixth Circuit panel affirmed. And after that Sixth Circuit decision, the governor declined to seek en banc review or to petition for a writ of certiorari. When the governor announced that decision, the Kentucky Attorney General moved to intervene in order to exhaust those appellate remedies, and the panel denied that motion. In an opinion by Justice Alito, the Supreme Court reversed that intervention decision 8-1. What we got was a short, crisp opinion that really unfolds in three parts. Part one is the question of how in the world did we get here, and how did we end up with an intervention case on the court's docket? Part two is establishing whether the Sixth Circuit in fact had jurisdiction to entertain the motion to intervene. And given that there is a part three, I think the spoiler alert here is yes, the court did have jurisdiction. And so the back half of the opinion deals with the standard for intervention. The majority opinion by Justice Alito was joined by all of the usual suspects, the Chief Justice, Justice Thomas, Gorsuch, Barrett, Kavanaugh, and I am certain that I am blanking on someone. It drew a separate concurrence from Justice Thomas. He joined the majority opinion, but also wrote to address a jurisdictional issue. A separate concurrence from Justice Kagan, who was joined by Justice Breyer. Again, kind of some disagreements with the majority on how they framed the intervention issue. And then a solo dissent from Justice Sotomayor. So we'll start with part one of that opinion. That's how we got here. In 2018, Kentucky passed a statute regulating dilation and extraction abortions. EMW, an abortion provider, sued the Secretary of Health and Family Services Cabinet, which is an agency of the governor's office. And EMW sued the Attorney General, sued both in their capacity as potential enforcers of the abortion regulation. Now, in Kentucky, the governor and the Attorney General are separately elected, which ends up featuring pretty prominently in how this case unfolds. And so in 2018, Kentucky had a Republican governor and a Democratic Attorney General. The Attorney General was Andy Beshear. The Attorney General was dismissed from that suit without prejudice. And of importance here, the Attorney General agreed to be bound by any final judgment subject to modification, reversal, or vacation on appeal. And the Attorney General reserved the right to, quote, all rights, claims, and defenses relating to whether he is a proper party in this action and in any appeals arising out of this action. The Secretary, at the governor's direction, and represented by Matt Kuhn in the governor's counsel's office, defended the statute. A district court judge enjoined the statute after a bench trial, and the Secretary appealed. During the appeal, Kentucky elected Attorney General Beshear as the new governor, and then elected a Republican Attorney General. So you still have a party split between the two offices, but they've essentially flipped control. The governor naturally appointed a new Secretary of the Health and Family Services Cabinet, but actually continued the appeal and defense of Kentucky's statute. But rather than handling that litigation himself, the governor actually retained the Attorney General's office as counsel to handle the continued litigation. And in a funny turn of events, Matt Kuhn had actually moved from the governor's office to the Attorney General's office, so he stepped in to brief and argue the appeal. And so what you have is basically a change of the office responsible for running the litigation, but the whole time it remains in my good friend Matt's hands. You had a divided panel of the Sixth Circuit, which affirmed the district court and upheld the injunction against this Kentucky statute. The secretary then announced that he was not going to seek en banc rehearing or petition for certiorari, but did not oppose the Attorney General taking over the case to exhaust those remedies. So the Attorney General's office, again acting through Matt, withdrew as counsel for the secretary and then moved to intervene as a party in his own right. The Attorney General's office also tendered a petition for en banc rehearing within the 14-day window that an existing party would have had to file that petition. So what you see is sort of no change to the appellate schedule, no change to the lawyers involved in the case, but a change in, again, the office seeking to defend the statute. That same divided Sixth Circuit panel denied the motion to intervene for three reasons. First, they thought that the motion was untimely because it came after years of litigation and after the panel had already issued its decision in the appeal. Second, the panel thought that the Attorney General had no substantial legal interest in intervening because he sought to pursue two discretionary and rarely granted forms of review, an en banc rehearing and a petition for cert. And third, the panel thought that intervention would actually prejudice the plaintiffs, would prejudice EMW in that case, because it included an argument on third-party standing that may or may not have been raised below. That's actually an ongoing matter of dispute that'll probably be resolved in some of the further proceedings. So the Supreme Court granted cert on the question of whether the Attorney General should have been permitted to intervene. So that's section one. Section two deals with whether the Sixth Circuit actually had jurisdiction to entertain that motion to intervene in the first place. This was incidentally the only point that attracted any amicus support for EMW, and it was a position that was unanimously rejected by the Supreme Court. EMW argued that the motion to intervene was jurisdictionally barred. This was a new argument that was raised for the first time with the court, and EMW argued basically that typically a non-party who is bound by a district court judgment, as the Attorney General agreed to be here, can file a notice of appeal of that judgment within the sort of usual Rule 3 and Rule 4 time limits. And because a non-party can obtain appellate review that way, EMW argued that a non-party shouldn't be able to circumvent those time limits by moving to intervene after the deadline is already passed. So EMW argued the Attorney General was a non-party bound by the judgment, could have filed a notice of appeal. It didn't. So his motion to intervene should have been treated as an untimely notice of appeal and rejected on that basis. The Supreme Court had absolutely none of that. The court noted that, now I'll quote here, "We do not read a statute or rule to impose a jurisdictional requirement unless its language clearly does so. And there's no clear provision of law here that limits the Court of Appeals jurisdiction to hear a motion to intervene, or at least not in the way that EMW asked." The court reasoned that what EMW really wanted was a mandatory claims processing rule. But claims processing rules are not jurisdictional, and so it was waived below, and the court was not going to entertain it. But for good measure and in the interest of giving guidance to lower courts, I'm sure, the court also explained why EMW's argument wasn't persuasive. And that was relying on the Attorney General's original reservation of rights, which we talked about in section 1, which included retaining the right to all claims and defenses in any appeals arising out of this action. And that reservation, the court reasoned, easily covers the right to seek an en banc rehearing or petition for cert. And of course, the Attorney General had only agreed to be bound by whatever version of the final judgment emerged after all appellate review had been completed. So with jurisdiction out of the way, the court moved on to part 3, which was the merits of intervention itself. The court first noted that there's no statute or rule that creates a general standard for deciding whether to allow an intervention on appeal. So if we have any practitioners or academics who are looking for a good topic, you might spend some time musing out loud about whether we need an intervention rule for the appellate courts, and if so, what that rule ought to say. But in the absence of a rule, the court has historically relied on the policies that underlie intervention in district courts, including, and in this case, most importantly, the interest that the party is seeking to protect through intervention. In Cameron, the interest was a big one, and I think an interest that matters to all of us at the Federalist Society. Is kind of at the core of the Society's mission, and that's the state's sovereign interest in enforcing and defending its duly enacted statutes. That means that a state's opportunity to defend its laws in federal court, the Supreme Court said, should not be lightly cut off. The court highlighted that a key element of state sovereignty is the state's right to structure its executive branch, and in particular, to designate multiple officials to defend its sovereign interest in court. So here, Kentucky had empowered both the Secretary of the Cabinet of Health and Family Services, and really in that instance, the governor, and the Attorney General to defend its sovereign interests. If I'm remembering the argument correctly, the Attorney General couched this as Kentucky creating a failsafe to ensure that its laws are always defended, and that if the state is actually going to withdraw from litigation, you really have to persuade multiple offices to give up the fight. The court suggests that as a constitutional matter, federal courts are duty-bound to respect the choices that states make about how to organize their executive branch and how they are going to assign litigation authority. This was the chief point, I think, where the majority and the Kagan and Breyer dissent disagree. For Justices Kagan and Breyer, this isn't really a constitutional question. It's just an important interest. But for the majority, it is a matter of constitutional federalism that federal courts must respect a state's, and heavily weigh a state's interest in defending its own laws. And so the chief error that the Sixth Circuit made was discounting the Attorney General's interest in taking up its defense of a state statute. Now, in a footnote, the court addressed the Attorney General's prior dismissal and points out when the Attorney General was originally sued, he was sued in his official capacity as someone who could enforce Kentucky's regulation. When he came back on appeal to intervene, he was intervening in his capacity as chief law officer for the Commonwealth and as the office principally charged with defending state statutes. With that in mind, the court said the rest of the intervention factors also favored the Attorney General, namely timeliness and the absence of prejudice to any of the other parties. The court, I think, reasonably held that the Attorney General was timely because he sought to intervene as soon as it was clear that Kentucky's sovereign interest would no longer be protected by the parties in the case. There was no need to intervene when the Secretary was still defending the statute, particularly when the Secretary had hired the AG to litigate the case. But once the Secretary decided to withdraw, the Attorney General very promptly moved to intervene, and as we noted in the first section, actually filed a petition for en banc rehearing within the timeline normally required for existing parties to petition. And so you didn't actually see any change to litigation schedule on account of the Attorney General's intervention. As to prejudice, the court noted that the third party standing issue wasn't the only issue in the rehearing petition, and that the Secretary actually could have raised third party standing himself if he had been the one to file the en banc rehearing petition. And it would have left the Sixth Circuit in the same position it's in now, which is deciding whether that third party standing argument was waived. EMW also argued that they had a reasonable expectation that when Beshear was elected governor, owing to his sort of pre-existing and campaign commitments to abortion rights, they had a reasonable expectation that he would in fact drop the suit. And so EMW, in fact, would not have to continue to litigate and could enjoy the fruits of their injunction. And the court spent about a paragraph explaining that this is not the kind of reasonable expectation that we take seriously when evaluating prejudice in a motion to intervene. Justice Thomas added a short concurrence. He joined the majority opinion in full, but wrote separately to talk about the jurisdictional question, making the elementary observation that only parties can appeal under the Federal Rules of Appellate Procedure, and that the Attorney General had ceased to be a party when he was dismissed at the beginning of the case. And so rather than treating the motion to intervene as an untimely notice of appeal, Justice Thomas points out the Attorney General never could have filed a notice of appeal in the first place. Justice Thomas does not believe that a non-party bound by a judgment actually has a right to appeal. Appeals, in his view, are reserved for parties. Justice Kagan also wrote a separate concurrence. She did not join the majority opinion, though her concurrence is actually really similar to the majority opinion. She took EMW's anti-circumvention concern a little more seriously. This idea that a party shouldn't be able to agree to be bound by a judgment, decide not to appeal, and then move to intervene after an appellate decision comes down. She thought that was a serious concern, but not one really implicated here, because in this case, the Attorney General did not appeal because he didn't need to. The substantive function of defending state statute was capably in the Secretary's hands until it wasn't. Kagan's sort of chief disagreement with the majority was over whether to frame the Attorney General's interest as a constitutional interest in defending a state statute or merely a really good reason to allow intervention. And lastly, you had Justice Sotomayor writing alone in dissent. And for her, the bottom line is that she thinks the Attorney General should have been bound by his early dismissal and should not have been able to re-enter a case years after it's already begun. It's important to note she didn't buy the jurisdictional argument from EMW, but she did fault the Attorney General for seeking dismissal in 2018 on the theory that he wasn't actually an officer who could enforce the statute, and then seeking to re-enter the case to defend that statute after the Sixth Circuit had issued a decision. And so for her, it was principally a matter of whether intervention was justified, not really a question of whether it was even permissible or if the Sixth Circuit had discretion to do it. I think a couple of the big takeaways here are number one, the federalism question of how do we treat a state interest in defending its laws, and to whom is that interest committed? So if you frame this case, and I think Justice Sotomayor's dissent probably makes more sense, if you frame the case as a lawsuit against the governor's office or against the Secretary of Health and Family Services or against the Attorney General, but the majority, somewhat subtly, instead framed this case really as a suit against the Commonwealth of Kentucky seeking to invalidate one of its laws. And the Commonwealth has the right to defend and vindicate its interests in its own statutes through essentially whichever officers it chooses to give that authority. And so particularly for those of you practicing in-state law or working for state governments, this case, and if we have any state legislators on the call or anyone advising state legislators, I think this case is really a call to think seriously about how your state structures the offices responsible for defending state law. The court has signaled that it is willing to defer to whatever choices a state makes, but that it will also hold a state to the choices that it makes. So this case, I think, differs a little bit from the Virginia election suit a couple of years ago, where the Virginia legislature sought to intervene in a case after the governor and attorney general had ceased defending a state statute. And the court essentially said, look, Virginia gets to choose its officers that will defend its statutes. It didn't choose the legislature, so the legislature is not going to be permitted to intervene here. Whereas in Cameron, Kentucky had in fact given the attorney general an interest in defending state statutes, and so we're going to respect that choice and permit the attorney general to intervene. The other, I think, is the other key issue here is the way that the court framed timeliness when considering a motion to intervene. The court doesn't seem terribly troubled by how long litigation has gone on prior to a motion to intervene. Timeliness is really measured from when the intervening party first understands it might need to intervene to defend its interest, or that the existing parties to the case are not adequately protecting its interests. So again, for all you Fed courts practitioners, this case is, again, I think, a serious call to just take a careful look at the way that you think about intervention, the way that you watch dockets. The court will be forgiving if you're prompt once you figure out that you have an interest that needs to be protected.
Thank you for listening to this episode of SCOTUScast. SCOTUScast is a project of the Federalist Society, a not-for-profit educational organization of conservative and libertarian law students, law professors, and lawyers, founded upon the principles that the state exists to preserve freedom, that the separation of governmental powers is central to our Constitution, and that it is emphatically the province and duty of the judiciary to say what the law is, not what it should be. Don't forget to subscribe to our podcast series, including SCOTUScast and Practice Group podcasts, on iTunes or Google Play. For an archive of past podcasts, as well as audio and video of past Federalist Society events, please visit our website at fedsoc.org/multimedia. That's fedsoc.org/multimedia.
This has been a FedSoc audio production.